State versus Rochelle Farnham, 17-262, commercial burglary, several counts of threat, terroristic threatening. Ma'am, who is your lawyer? Can you hear me?
Yeah, can you hear me?
Yes, I can. Who is your lawyer, ma'am?
I don't have one.
Okay.
At this time. I have applied for the public defender. Can you hear me?
Okay, the public defender's been appointed to represent you. And I guess you're here for an arraignment.
Judge, that's correct. I met with her at the jail yesterday. We'll waive any of the information in her plea of not guilty, and she'd like to be heard on bond, Your Honor.
Okay. What's your bond set at?
I believe it's over.
Is that 100,000?
Right.
What?
100,000, Judge.
Well, what did you want to say about the bond?
Judge, she is a local resident. Get her paperwork here. Do you have her yellow sheet? She has no prior convictions, Your Honor. Like I said, she does live here locally. She is 30 years of age. She does have three children, and she is in contact with them. We think that a bond in the amount of $10,000 is appropriate, as opposed to the high bond that's set right now, Judge.
I don't know how it got set at 100. It's actually set at 50, according to what I have. Your Honor, this lady is charged with allegedly stealing 2 firearms, some other personal property, and a large quantity of jewelry valued in excess of $30,000. I think her $50,000 bond is sufficient.
Tell you what, I set the bond at $15,000, 10% of it will be in cash.
Can we go any lower? I mean, I'm not a flight risk, obviously. I don't have.
Let's see.
What's the case number? 260.
She'll reappear before Judge Webb on July 6th at 9 o'clock. And that's all we can do today. Thank you.
Rochelle, you can take up. You're going to have a different judge. You'll see him next week. If you want to take up the issue of bond, then you can as well. Okay.
Okay, so what exactly went on today? Because I really can't hear very well.
You can stand aside. Thank you. What's State versus Mitchell Tikinchuk, 17-264, charged with residential burglary, arson, filing a false police report, forgery, several other crimes. Looks like we're here for an arraignment.
Judge will plead not guilty, seeing as how he's going to be on Division 4 and he has a probation hold. We'd ask that he be brought in front of Judge Webb next week for any bond issues that might be relevant to his case.
Okay, we'll enter the plea of not guilty. We'll have you reappear on July 6th at 9 o'clock. That's all we can do today. Thank you. State versus Jerry Brown, 17-260. Fleeing is the charge. And looks like this is also for an arraignment.
Judge, based on our appointment, he'll enter a plea of not guilty. He also has a probation hold that will probably need to be discussed with Division 4. Bond's not an issue at this point in time.
Okay. We'll enter the plea of not guilty. Reappear on July 6th at 9 o'clock, sir. That's all we can do right now. State versus Sarah Smith, 17-257, charged with battery in the 2nd degree.
Your Honor, I've been retained to represent Ms. Smith privately.
Okay. She already entered a plea of not guilty before Judge Webb. Her next appearance is August 24th at 10 o'clock. for a free trial. State versus Russell Cleland, 17-193. Possession with purpose to deliver controlled substance, defaced firearms, several other charges.
Your Honor, Mr. Cleland is here on a reappearance. There is no action to take in his reappearance. The case is moving as it is. We'd ask it be left on the scheduling order. I will inform Mr. Cleland that through my negotiations with Mr. Etheridge that he's in jail because of a failed drug test, Your Honor. He will be released later today.
Okay.
Is he still subject to drug tests?
Yes, yes.
You may stand aside, sir. Mr. Robbins, Wayne Robbins, you may stand aside, sir.
Yes, sir.
Okay. Wayne Robbins, hot checks.
Judge, we represent Mr. Robbins. He is set for trial in November of this year. He's here for a reappearance today. At this point in time, the defense is moving for a OR bond for Mr. Robbins. Judge, he's being held on, as you mentioned, hot check charges. The allegation is that there's about $4,700 in hot checks were written. Mr. Robbins is a lifelong resident of the Mountain Home area. He lives on Highway 5 North now, where he's lived for the last 2 years. He works in West Plains. He was picked up on this warrant in West Plains. He sat in jail there for over a month. He waived extradition, but he's been in our jail since then for almost, since April 8th of this year. So, Judge, at this point in time, we think that he is a prime candidate for an OR bond with whatever restrictions the court wants to put on him with regard to reporting or anything like that. But we think that for him to put up any bond money would be better spent towards going toward restitution in this matter, if that's what it comes down to.
Your Honor, he's allegedly written 8 checks of about $4,000 to businesses here in Mountain Home, 3 different businesses. I'd like him to post a cash bond if he could. He owes about $4,000.
Does he have a qualified co-signer on a surety bond?
Judge, his brother lives here. I don't know if he would be able to sign for him or
Why
not.
don't you check on that. If he's qualified, that's the bond, we'll go from there.
A signature bond?
Yeah, but if he's qualified, in other
Okay.
words, he's got the money. We'll look into that.
If could I inquire of him?
Yes.
Wayne, can you hear me?
Apparently, yes, sir, I can.
Okay, does your brother live here in Mountain Home?
Yes, sir.
Does he work here in Mountain Home?
Yes, sir.
Does he own real estate here?
I'm sorry, I can't hear you.
Does he own real estate here?
Yes.
Okay. And are you close with him to where he would sign a bond for you if he qualifies?
Yes.
Okay. What's his name?
Tom Robbins.
Tom Robbins?
Yes, sir.
Okay. Is he a convicted felon? Do you know?
No, he's not.
Okay. Judge, I don't know what other information you'd like from him.
I guess whether his brother's willing to do it.
He said he thinks he might be.
Well,
Tom Robbins?
If he's qualified, we'll sign an affidavit to that effect, sure. He can
Okay.
co-sign the signature box.
All right. All right. Thank you.
State versus Tommy Hitt has that's 17-223, 17-134, 16-393. Basically drug cases. Maybe a gun involved.
Judge, when we were here last, Mr. Hitt was required to post a $5,000 cash bond, which he did, and then subsequent charges were filed. I don't know if you have the affidavit before you in 17-223, but we probably need to look at that to discuss the bond issue. Judge, even if taking the allegations in the affidavit is true, we're not denying that the allegations are serious, but we would like to point out that this was a residence that Mr. Hitt had recently lived in, and that he had items of personal property in the residence, that no other damage was done, if the allegations are taken as true in the affidavit. Having had posted that $5,000 cash bond and whatever other requirements the court puts before him moving forward, we think that that's an appropriate amount to assure his reappearance, even in light of the fact that he has these new charges, Judge.
Your Honor, we have arrested Mr. Hitt. The first time looks like November of last year. He bonded out of jail. We arrested, that was for possession of firearms by certain persons, possession of drug paraphernalia, no driver's license. He bonded out of jail. We then arrested him in March of this year for possession of controlled substance, methamphetamine, driving on suspended license, fictitious license sticker. He bonded out of jail. We arrested him in May for possession with purpose to deliver methamphetamine, Class B felony, possession with the intent to use drug paraphernalia to distribute methamphetamine, Class B felony, use or possession of drug paraphernalia, Class D felony, a proximity to certain facilities, an enhancement charge, maintaining a drug premises, a Class C felony. He was allowed to bond out of jail. That was the $5,000 bond. That's when we arrested him approximately 2 weeks later at June 1st for residential burglary. Judge, this gentleman is entitled to a bond. He's not entitled for you to say, oh, you shouldn't have done that and get out of jail. If you want to give him a $25,000 cash bond, I'm not offended by that.
What's the bond set at now in the residential burglary?
Judge, I think it was $25,000 cash or surety, and I don't know if there was a revocation filed.
It's $25,000, Your Honor. You know, if the court could give the man an ankle monitor and confine him to his house, that would be, we'd like that condition. At least the citizens of Baxter County would like that.
Does he work?
Not right now, Your Honor.
I disagree with that, Your Honor. I think he's working. He's just not working. It's something we want him to work at.
On this particular case, 17-223, are allowing to be released on an ankle monitor. Is there anything to be done in the other cases?
No, Your Honor. We'll leave those as scheduled.
Okay.
Judge, what are the restrictions on his ankle monitor?
Well, we'll just keep up where he's at.
Okay.
Thank you, Your Honor.
We'll take up Ms. Reinhardt's case, State versus Reinschmidt, I'm sorry. Carol Reinschmidt, 17-17. Possession of firearms with certain persons, defaced firearm, public intoxication. And let's see. She's appearing for an arraignment.
Judge, we've been appointed. We'd waive reading of the information in her plea of not guilty. We'd like to be heard on bond, Your Honor.
Go right ahead.
Judge, Miss Carroll's been in jail for approaching 40 days now. She has she is on probation out of Greene County, Arkansas, and I think that's the allegation in this case, is that she was in possession of a firearm. Without litigating that today, Judge, though, we request that the court set a $1,500 bond to assure her reappearance. I think that's appropriate.
I don't want to litigate it either, but the allegation here is simply more than this lady, while on probation and a convicted felon, was in possession of a pistol at a business here in Mountain Home. I'd like you to read the affidavit, or at least the affidavit for probable cause.
Do you have an extra one?
I read it.
Okay.
Set the bond at $2,500, 10% of the in cash. Anything else?
No, Your Honor.
That's all we can do today, ma'am. Thank you. State versus Kathleen Perry, 17-215. Delivery of controlled substances, several counts. Unlawful use of communication device, several counts. And let's see. She's appearing for attorney status.
Judge, I believe we've been appointed to represent Kathleen. I've got a file set up with her already. I met with her at the jail on Wednesday. At this point in time, she's been unable to bond out. We would request that the court consider in her case a $2,500 bond. I'm familiar with Miss Pieri being involved in a domestic relations case that she was a party to. She's lived here for many years. Her parents both live here. All of her children live here. Her ex-husband lives here. I don't think she's at all a flight risk, Judge. I think that she also, I don't think that. I know that she also has some significant mental health issues that she's not being medicated for at this time because of the requirement that she see a doctor before those can be re-prescribed to her. We're not in a position to resolve the case soon, so at this juncture, we would ask that the court set a $2,500 bond for her.
Your Honor, this was done. We had a bond reduction on this lady. Her bond was originally set at $20,000. This court reduced her bond to $5,000, 10% of which would be cash. That was done the last time you were here.
She's still there, Judge.
Well, I'm familiar with her also from domestic relations cases. 1,500, 10%, minimum 10% cash.
Thank you, Your Honor.
State versus Stephen Hutton. Residential burglary, theft, firearms, several counts, theft of property.
Judge, I represent Mr. Hutton. We have received a plea offer that I've gone over with him more than once now, and he's declining to accept that offer. His trial's not until August 29th. He's being held on a bond now, obviously, that he can't make. He's requested that I ask the court to reduce his bond to $5,000 cash or surety. He does live here locally and has for a long time. He has no prior felonies. And I don't even know if he has any misdemeanors, to tell you the truth. But based on those facts, we would ask the court to consider a $5,000 cash or surety bond in this matter. He's been in jail for 90 days, Judge.
Yes.
Your Honor, this gentleman's charged with breaking into someone's home and stealing 5 Glock pistols and then selling them the same day, purchasing them the same day. A $35,000 bond is a reasonable bond for someone with that kind of activity.
I think I just want to leave it where it's at. $17,155, State versus Brandy Barnes. Possession with purpose to deliver controlled substances, drugs and firearms, driving violations. Also 17-114, which is a drug case, 17-27, which is a drug case.
Judge, we have filed a motion to suppress. I believe it's in the 1727 file.
Okay.
We would need to take that up prior to the trial. The trial's in late August. He's got 2 other cases, as you mentioned.
Okay, we can hear the suppression hearing on July. Well, let me see. Let me look at the scheduling order first.
He's to be back anyway on July 27th on the other cases.
July 27th.
Yes, Your Honor.
Okay, we'll have the suppression hearing on that date.
And Your Honor, I'm going to, we've argued bond reductions before. I'm going to speak with the prosecutor at the break and see if we can come to an agreement
Okay.
on that matter for today's purposes.
Very well. That's all we can do right now, sir. Thank you. 17-153, State versus Zachary Giltner. Delivery of controlled substances, several counts. Unlawful use of communication device, several other drug-related charges.
Judge, I represent Mr. Giltner. He has been diligent in speaking with Ty Cotter with regard to his treatment program here in Mountain Home. He has a trial date set for late August. I believe that if the court would consider letting Mr. Giltner bond to Care Center Ministries, that his time might be better spent there than in the county jail while he's awaiting trial, we would request that the court order that today.
Judge, these are deliveries. These are 4 counts of delivery of methamphetamine. The state makes no will not recommend this gentleman go to Care Ministries, Your Honor.
Judge, I have been in touch with the director of that program, and he has told me that he's willing to accept him. It's not just something that he's asking for without having looked into it and done the groundwork for it. He does request the court allow him to do that.
And I recommend that people go to Care Ministries all the time. That's people we catch with for possession. We catch them in charge, and they really made a mess of their own lives. And I tend to draw a line between someone who does drugs, who I pity, and someone who sells drugs, who I do not. And I do not recommend that this gentleman go there. I recommend that this man face the evidence that's against him, and we allow a jury in Baxter County to see what that's worth.
Well, considering the charges, I don't want to just release him. Or if you can work out some other alternative, I would certainly listen to it.
Thank you, Your Honor.
State versus Gordon Cox, 17-151. Drug paraphernalia. Possession with purpose to deliver controlled substances. Who represents you, sir?
Mark Cooper, sir.
Mark Cooper. Okay, we'll get him in here. We've got Gordon Cox before us, and we're here for a pre-trial hearing if necessary.
Your Honor, there's no action to take in Mr. Cox's case today. I'm being handed discovery. Brian,
Gordon. Oh, he goes by Brian.
are they taking you back today, or do you know?
I don't know. I'd like to speak with you if possible.
Okay, all right. I'll try to get over there before they take you back, okay?
Thank you.
No action, Judge.
Well, thank you, sir. You may stand aside. State versus Dean Thompson, 17-139. Delivery of controlled substances. Possession with purpose to deliver. Paraphernalia. Conspiracy. He also has 136, which is a drug case also.
Your Honor, that's Mr. Bayless's private case.
Okay?
I don't believe that Paul's not in here right now, but I don't think he was planning on taking any action today with Mr. Thompson. If I'm wrong, we can recall him.
Let me see.
Can I say something?
Let's see what we're here for today. This would for pre-trials. I take it since Mr. Bayless is not here, there are no pre-trial matters. Yes, what is it, sir? Did you want to say something, Mr. Thompson?
This is the second.
Okay, I couldn't hear you, but I cannot hear you.
Charges, I have nothing but. Let me give Paul, Judge, he's here. Charges are,
We're gonna get your lawyer in here. Just hold on one moment. Sometimes spraying in tin cans would work as good. Thompson.
Yes, Your Honor. He's here for pretrial. However, we checked the crime lab yesterday afternoon. It has been submitted some time ago. However, we don't have the results, so we can't proceed with pretrial at this point. There is a collateral issue as to getting his belongings. I met with Mr. Etheridge this morning. We're going to provide him a list of things that are in a vehicle that's currently seized, and so I think that's proceeding. If we need anything with the court, I'll request a hearing.
Okay. Was it the belongings in your vehicle? Is that what you wanted to talk about, sir?
I'm in the bond reduction.
Your Honor, as far as the bond reduction, I'll talk to the court at the break about that.
Okay, that's
Okay?
fine. Well, your lawyer's gonna pursue that, so we'll go from there.
The charges are wrong on my paper.
Charges are wrong, okay? He's gonna look into that too.
We'll have a conference at the break, Your Honor.
Okay. At this moment, that's all we can do, sir.